Welcome back, everybody. Will Worsham joins us now for this week's Speaking Legal discussion, where he answers a viewer's legal question right here on the air. You ready, Will?
I'm ready.
All right, here we go. My current landlord informed me that since I didn't give 30 days written notice that I was moving, I would have to pay the next month's rent. And if I didn't, they would pursue the funds. This is not listed in my rental contract. Is there a state statute that says a tenant must give 30 days notice to the landlord before vacating the premises? On the hook or not?
Okay, well, there's a couple of issues that arise here. One of the facts that we don't have here is what the original term of the rental contract was for. So if this was a one-year lease, as many are, if you break that lease 6 months in advance, with or without 30 days notice, technically, by the law, you're on the hook for the full lease agreement because that's what you agreed to do.
You signed off.
You signed it. You agreed to lease that house, that apartment, for a full year. And so if you move out ahead of time, you're in breach of that lease. And technically, by the law, your landlord's able to sue you not just for 30 days, not just for the next month, but for that entire rental period because that's what you agreed to. That's what they had a right to expect. Now, realistically, practically speaking, around this area at least where I practice, normally if you do break a lease, a residential lease, the courts aren't typically going to hold you to the entire lease period, but they are going to hold you at least through the month in which you had a partial tenancy in. So that would mean, like, let's say you moved out on the 5th and rent's due on the 1st, as it is in most leases, you're going to be liable for that entire month's rent.
The whole month.
Right, because it's not reasonable to expect that a landlord can just immediately turn around and put a new tenant in there. To mitigate their damages, which is the actual legal term, in any type of contract dispute, leases included, a person who's damaged, so the landlord in this case, has a duty to mitigate their damages. That means, yes, by law I could go out and sue that person for the full 6 months, but I have a duty to try to find somebody else to take over that lease and take over that breaching tenant's position, thereby relieving them from the obligation so that my damages are not full.
Because a lot of times the courts just don't enforce that whole 6-month deal.
Well, that's true, and that's really why the whole mitigation of damages thing is, as a landlord, you have a duty to mitigate your damages to try to find a new tenant, and they just assume that you're going to do that, especially because it's in your financial best interest to do that. But back to the question at hand. Missouri does have a statute. It typically pertains to situations where there's not a written lease, and in this one you could almost infer that there wasn't a written lease pertaining to this particular section about 30 days notice. If you're going to end a unwritten lease, then you do have to provide 30 days written notice
because
to
of
do
state
that.
statute.
Because of state statute. So I think that probably the landlord is well within their rights to seek that 30 days that recompense essentially for the lost rent in this scenario, and frankly maybe even more depending on what the circumstances were of when they moved out in the lease cycle, what remaining period was still there on the lease, and the circumstances in which the breach occurred.
Well, a tenant says here it was not written in the lease. Does the tenant have ground to stand on by saying, I know it's state statute, but you didn't want it?
Well, ignorance of the law is no excuse. And so, you know, the fact that they didn't know isn't going to excuse them that. And there's still the possibility that they don't have any right to breach this lease with notice or not. And so in that scenario, 30 days notice is actually quite gracious that that's all the landlord is asking for.
That, depending on the circumstances, because you say if you're 1 day shy, if you're 6 months and 1 day, you could be on the hook for the other 6 months.
It's possible that you could be, yes.
Oh, that's a sticky situation. All right, if you have a legal question for Will, email him at wworsham@color10.com and he'll answer your question on the show. Good to see you again.
You too.
All right, see you.